The Equality Act is a bill in the United States Congress that, if passed, would amend the Civil Rights Act of 1964 to prohibit discrimination on the basis of sex, sexual orientation and gender identity in employment, housing, public accommodations, education, federally funded programs, credit, and jury service. The Supreme Court's June 2020 ruling in Bostock v. Clayton County, Georgia protects gay and transgender people in matters of employment, but not in other respects. The Bostock ruling also covered the Altitude Express and Harris Funeral Homes cases. The bill would also expand existing civil rights protections for people of color by prohibiting discrimination in more public accommodations, such as exhibitions, goods and services, and transportation. Much like the Bostock v. Clayton County decision, the Equality Act broadly defines sex discrimination to include sexual orientation and gender identity, adding pregnancy, childbirth, or a related medical condition of an individual, as well as because of sex-based stereotypes. The bill also defines this to include intersex traits. The intended purpose of the act is to legally protect individuals from discrimination based on such. While various similar bills have been proposed since the 1970s, the modern version of the Equality Act was first proposed in the 114th United States Congress. During the 116th Congress, it passed the United States House of Representatives on May 17, 2019 in a bipartisan 236 to 173 vote. However, the United States Senate did not act upon the bill after receiving it. Even if they had, President Trump signaled that he would have vetoed it. On February 18, 2021, the act was reintroduced in the 117th Congress. The House passed the act by a vote of 224 to 206 on February 25, with support from 3 Republicans. The bill then moved on to the Senate for consideration. Opponents of modern versions of the Equality Act variously anticipate negative effects, including with respect to freedom of religion, freedom of speech, and women's rights. As of 2020, 29 states had not outlawed anti-LGBT discrimination, with members of the LGBT community being given little protection at a national level, and 2/3 of LGBT Americans in the United States reported facing or having experienced discrimination in their personal lives. The Equality Act seeks to legally protect individuals from such discrimination, applying existing state anti-LGBT discrimination laws nationwide. The Equality Act seeks to incorporate protections against LGBT discrimination into the federal Civil Rights Act of 1964. Specifically, it prohibits discrimination based on sex, sexual orientation, gender identity, and intersex status in a wide variety of areas including public accommodations and facilities, education, federally funded programs, employment, housing, credit, and jury service. It also seeks to expand existing civil rights protections for people of color, women, and other minority groups by updating the definition of public accommodations to include places or establishments that provide, according to the text of the Act as introduced in the 117th Congress, discrimination based on sexual orientation or gender identity by governments violates the Equal Protection Clause of the 14th Amendment, saying, discrimination by state and local governments on the basis of sexual orientation or gender identity in employment, housing, and public accommodations, and in programs and activities receiving federal financial assistance, violates the Equal Protection Clause of the 14th Amendment to the Constitution of the United States. In many circumstances, such discrimination also violates other constitutional rights such as those of liberty and privacy. Under the Due Process Clause of the 14th Amendment, the original Equality Act was developed by U.S. Representatives Bella Abzug sought to amend the Civil Rights Act of 1964 to include prohibition of discrimination on the basis of sex, sexual orientation, and marital status in federally assisted programs, housing sales, rentals, financing, and brokerage services. The bill authorized civil actions by the Attorney General of the United States in cases of discrimination on account of sex, sexual orientation, or marital status in public facilities and public education. On June 27, 1974, H.R. 14752 was referred to the House Committee on the Judiciary, but did not proceed to a vote in the full United States House of Representatives. From 1994, the more narrow Employment Non-Discrimination Act was introduced, but faced opposition over whether transgender Americans would be protected. An expanded version of ENDER which included both sexual orientation and changed sex to gender identity in its protections passed the United States Senate in 2013, but did not advance in the House. A Reuters, Ipsos poll conducted in May-June 2019 found that most Americans do not know that LGBT people lack federal protections. Only one-third of respondents,